Again, thank you for joining us. This is going to be just a brief overview of a 30,000-foot survey of just some recent changes in privacy law focused here in the U.S., but it does relate in many ways to some of the things that have already happened in Europe, and also builds upon what has already happened here in the U.S. with California. And so we're going to talk about those and how they relate not only here, but across the Atlantic, and how if you are engaged in business in both areas in particular, these recent changes may give you a bit of a leg up, a bit of a leg up on U.S. businesses and U.S. businesses if you're doing business in California, and/or either doing business in Europe or considering doing business in Europe. These changes again will allow you to hopefully maybe marry some differences between what has happened in Europe with GDPR and what is now happening in the U.S. with California. So let me go ahead and share the screen and we'll get started. And as always, just briefly, maybe I didn't give a good enough introduction. I am an attorney here at Ridge House Law, and we do this privacy situation a lot. We get lots of questions about revising website privacy policies and what does that look like, and in the landscape, particularly in the U.S. here, as it changes very frequently. Lots of developments in the last 3 or 4 years, and it's a very, very hot topic, very happening topic. So we do get lots of questions about that, and this is kind of a preview of maybe what's to come in many ways. So let me go ahead and share the screen, and we'll get started. Okay, so just to begin with a baseline, in case you're not familiar with what has happened in California in the last couple of years. So a couple of years ago in 2018, California did enact the California Consumer Privacy Act, or the CCPA. It does apply to California residents. And probably the best way to summarize and describe what the CCPA does is it really establishes a right to know how data and information is being collected, what it's being used for, and does give some control, some very, very loose control over what happens to that data, particularly if there's a sale of that data. But generally speaking, a right to know is maybe the really, really great summary phrase for what the CCPA does. It applies to for-profit businesses with gross revenue above $25 million annually, businesses that collect personal information of at least 50,000 California residents, and it does also segregate those out to households or devices, so it's fairly broad in its scope, and or it counts to businesses that derive at least 50% of their revenue by selling personal information of California residents. So it is quite broad, and there are obviously a lot of companies that would fall under that. And some other features, it does include an opt-out option, very different from GDPR, as we'll see in just a minute, where there's opt-in options in many cases. There is an express right to opt-out, and then there's some rules about what happens after that opt-out that may include an opt-in, but generally speaking, an opt-out is kind of the feature of the CCPA. It does include a notice of collection requirement, and it does include a very limited right to delete. Includes an anti-discrimination provision for people exercising these rights. And there are lots of kind of 12-month checks built into the CCPA. So really every year, a company should be renewing, refreshing its privacy policy, should be updating customers on the information it's using, how it's using it. And then there's that 12-month feature kind of also very much plays into those opt-outs and how that works. So just to get a little more in depth on that, the opt-out option is related to sell. So if you're not selling information, the opt-out is not really part of the CCPA. And then the same time with that notice of collection, it again is related to sell, when you're selling information, and you must provide that notice of collection at or before the time of collection. You also must include a do not sell link. So if you're selling information, not only in that notice of collection must you do that at or before the time of collection, but you must provide a do not sell link. that they can log on and then opt out of that sell ability. The CCPA does apply to natural persons, so it's not businesses, it's not any other type of entity, it's just simply people and individuals, California residents. And then the personal information, which we all can probably guess, we all kind of know what that looks like, but generally speaking, the legal definition is basically, can we get down to a person or a household? Do we know with some certainty who we're talking about? So that's how that works in terms of not only who we're after, but what we're after, what type of information. And that includes, as you probably can pretty quickly gather, social security numbers, financial information, email addresses, geolocation, biometrics, anything that really gets down to that very specific level of an individual person or a group of very small people in a household or a specific device, it's going to be counted in the CCPA. Okay, so how does this compare with GDPR? I do have a summary of the GDPR, but I'm not going to go really in depth. The GDPR has been around for a good bit longer, several years longer, and I feel like we're all at least fairly, hopefully, generally speaking, aware of what the GDPR does. But in summary, it does do some things that the CCPA does not do, and it grants some rights that the CCPA does not grant. Although, as we'll find out here in just a few moments, that is about to change. One very quick note on the CCPA. Given that a lot of this was not just the last year or so, there are regulations still being written. There are still kind of enforcement mechanisms, what that's going to look like. And on that note, there's not a lot of teeth to the CCPA. There are, GDPR has some very clear enforcement mechanisms, and the CCPA does have some things, but it's relatively open and in many ways on the consumer and the business to kind of work that out. Whereas GDPR has very clear enforcement mechanisms, but as we're about to see, that's about to change in California. So with the GDPR, again, it applies to data subjects, which is a really interesting term. Obviously, that applies to European residents and citizens, but it would certainly appear to apply to really anyone who is in the EU or is subject to the entities that are subject to the GDPR. So it is very broad, whereas I think the CCPA is very clearly defined to California residents. GDPR can be exceptionally broad. And in both cases, they both have what's called extraterritoriality. So they apply outside of California. If you're a business here in North Carolina and you are collecting information on a European Union citizen, if you're collecting information on a California citizen, and you fall into the GDPR scope, then both apply to you, regardless of the fact that you're in North Carolina. So businesses that fall under the GDPR, those would be entities based in the EU and entities outside the EU that sell goods or services or products to individuals in the EU, or businesses that monitor the online behavior of data subjects. And again, that's quite broad. So in both cases, the scope is outside of their specific territories, and in both cases it is rather broad. But I think data subjects is a good bit broader, or it can be anyway. So very similar types of personal data. Again, I think we all can kind of understand what that means. Specifically, if you're processing data or if you're collecting, different types of data, definitely want to make sure the data you're collecting is included in either of these regulations. But I do think in a very general term, we all can understand what that term means. Do have to make disclosures about collection and use, much like the CCPA. It does include an express data security requirement, whereas CCPA has some guidelines and some please do and please take care of data. There is no express real means of enacting a data breach in most cases. There are a handful of cases with the CCPA, but not. It's very, very specific, whereas the GDPR has a much broader data security requirement and steps that one must do procedure-wise. There's also a notion of affirmative consent, which is really built into GDPR, not so much in the CCPA, except in very limited circumstances, with sale. Once someone opts out, they then have to opt in, and only after a period of time, after 12 months. And also, as we all know with GDPR, we're dealing with the rights of deletion, the right to correct inaccurate information, the rights to object or to otherwise alter how information is being used or being processed. So very, very clear, very specific rights of data subjects to manipulate and control how their information is used. Again, that is somewhat in the CCPA, but a lot of the rights that we all have come to familiarize with GDPR are not expressly in the CCPA and not really part of the CCPA. So that is how they differ. Again, the GDPR gives very explicit rights in many cases about how data must be used and what the person who the data is being collected from, what they can do with the data. Whereas I think CCPA, as we said a few minutes ago, it is largely a right to know what's being done with my data, and then some very limited instances where an individual can go after that data or manipulate how that data is used. But that has changed, or is about to change, I guess maybe is the best way to say it. So earlier, just a few months ago in November, California passed Proposition 24 on the ballot in November of a couple of months ago. And it passed the California Privacy Rights and Enforcement Act of 2020, or the CPRA. The CPRA was voter approved, as we said. 56% voted for it, so roughly 44% did not. So not an overwhelming landslide, but a convincing victory nonetheless. It is effective January 1st, 2023, with enforcement starting July 1st, 2023, so 6 months later. And I think that's maybe the biggest encapsulation of what the CPRA does. It provides a very clear enforcement mechanism and grants some very clear rights, much like GDPR. So the CPRA is moving California very close to what GDPR already does. And we're going to see some of what that is. But I think, as we talked about at the very outset, I think what is really neat in a way for businesses is that this gives a business an opportunity to, over the period of the next handful of years, to basically marry what's happened in the U.S., which has been obviously not on the level of GDPR, but also what's been done with GDPR. So now I think in the future, just a handful of years down the road, a larger U.S. business or a U.S. business dealing with the types of things covered by California's protection laws will largely be able to deal interchangeably in Europe and in the U.S. And they're very similar rules. The processes may be slightly different, but the rules themselves, the rights themselves, are in many ways the same. So the CPRA builds on the CCPA. It is expressly intended to do so. The Proposition 24 starts out by immediately saying, we're enacting this to build upon what we've already done. And we want to give consumers the clear rights to manipulate and control their data and direct how it is used and how it's collected and how it's processed. So it's very express, very clear what the purpose of this enactment is. As we said, it does incorporate new rights that will largely track with what GDPR grants to data subjects. And again, just to reiterate, it is enacted expressly to strengthen and further consumer rights. So one of the first ways, and maybe among the most important ways, is it does grant an express right to request deletion of data. And obviously the CPA did not feature this largely. Again, I think there was a very narrow way to request some deletion, but not broadly, whereas this grants a very broad perspective to delete data. And that really holds true to what's unique about this. It holds true to downstream data users. So companies that acquire data from the initial collection company, be it through sale, be it through some type of service agreement, be it through another contractual relationship of some type, that it applies. And that is a really interesting, unique feature that is going to really push down some information and push down some requirements on third-party, tertiary, and lower companies. And that requirement is generally across the board unless there is some reasonable necessity to maintain the data. And some examples for that would be if you have to complete the transaction, if there's an ongoing contractual relationship of some type, or there's some other legitimate business purpose, which is, if you're familiar with GDPR, very similarly tracks with some of the business purpose exemptions in terms of how you manipulate data. So again, I think it's going to be a lot of not necessarily overlap, but a lot of similarity in how this plays out. It also includes identifying, repairing errors or problems with functionality, and it also includes things like free speech and obviously any type of other competing right with regard to information. So outside of these exceptions and a handful of others, there's going to be an express right of deletion. So there's going to be also the right to correct. Again, the right to request that inaccurate information be revised and corrected. Of course, that is based on the commercially reasonable efforts of those companies. And again, I think it's important to note here that is going to really focus on how this enactment is built out through regulation. A lot of the research materials and things that we've looked at really emphasize, and CCPA was like this, GDPR was like this a few years ago, where we have this text, we have it, we're not sure how it's going to be applied and enforced and interpreted. And so there's going to be some catch up going forward the next couple of years about how California is going to interpret this. But commercially reasonable efforts, I think we can all, again, have a decent idea of what that might look like. Is it overly burdensome, or is it just astronomically expensive to fix this information in some type of way? That would obviously probably fall outside of the inaccurate or the correction requirement. Very clear expanded opt-out. We really don't quite get into the full opt-in of GDPR, but we do get to the very clear, very express, much broader opt-out. So, and I think the primary way that acts is it not only acts in terms of selling information, which was a feature of CCPA. We now have a clear opt-out when sharing information also. And I think that is a fundamentally different and much broader requirement. So if information is being shared, it is now added to the requirement that there be a very clear opt-out. So that includes the notice of, let me back up here. So yeah, the notice of collection. So that includes the notice of collection, as well as the do not sell or do not share link. There's no sharing or selling information for an individual under 16 unless you have parental consent, and that is where the opt-in comes in. So you do have to have very clear consent there. And there's also no selling or sharing after the opt-out unless you have subsequent consent. Again, that's already a feature built in, but it just adds sharing to that. And there is a 12-month window, and again, going back to that 12-month thing with the California rules and the CPRA continues that. Every 12 months there should be a refreshing, and if there's been an opt-out, the business can't really reach out for that opt-in until that 12-month period is passed, again, generally speaking. It also adds a new term, and again, it's really interesting how this happens. And I think it's really unique, and if you're, hopefully we all care about privacy, and I think this is really interesting in terms of its functionality and what it's going to do once this is built out, and we kind of see how this is going to play out. The CPRA adds a new definitional word, sensitive personal information. So not just personal information, but it identifies specific types of information that California voters feel is different and should be subsequently treated as such. So you must receive a subsequent consent after the opt-out, much like the selling and sharing information that we just talked about. And again, going back to that third-party tie-in, service providers and contractors are required to comply with use restrictions once they learn of those restrictions, but only to the extent that there's a written contract between the primary collection entity and that service provider. So I think it's going to really tie in how these parties relate to one another, and parties I mean by businesses. So if you have several service providers, or perhaps ISPs, or some other type of web development, web browser. I mean, anyone who's providing service to that forward-facing website, or that forward-facing, some technology collection entity or collection medium, it's going to push down the importance of having in writing what those companies have to do. And I think that's great. Everyone should will be able to know how that's happening and what that looks like. And I think it also is important that these companies now talk to one another if they're not already doing that, and learning how, and figuring out how they're going to allocate these compliance and restrictions. So it does push that down and tie in other third-party service providers. It also includes a limit the use of my personal information link. And much like the do not sell link, that must be clearly listed on the business internet homepage. Now, sensitive personal information. In a way, it's not that much different than what we outlined earlier with personal information, but it expressly puts forth what we're talking about. So things like account information. And by account information being like an email address and login, or some type of identification credentials that would gain access to that account. So precise geolocation, things around personal beliefs and philosophical or religious beliefs, electronic messaging content. So not just the fact that an email existed, but the content of that email, the content of the text message, genetic information, biometric information, health information, and other things that get into the really intimate nature of our lives. So, this is really interesting. It's really interesting to see how, in going forward, how California is going to build out how it's going to track this and how it's going to enforce this. And, what, obviously with something that this expansive, this broad, there inevitably will be some hiccups in how we look at this and how companies, collect this information and process or comply with this. So there's going to be a real learning curve, I think, and in terms of how this relates. And then miscellaneous. The CPRA adds a requirement that businesses with a website provide individuals a means of making these data requests. So the right of deletion, the right to correct information, really any of those requests that are directed toward businesses must be on the website. This is new. There with the CCPA, there were basically several ways that one could comply, but this very express website requirement is now a feature and requirement of the CPRA. So if you have a website and the CPRA and the CCPA apply to you, if you have a website, you need to make sure you have, a couple of years down the road, make sure you have that the ability to receive a data request or an information request. Again, it also adds, and this is again bringing it more in line with GDPR and somewhat distancing itself from the previous California Act, is that it allows data requests to go beyond 12 months in some instances, and that would be if there's no disproportionate effort required by the business, and if the business actually can receive that information. So it does expressly say in the CPRA that if the business literally cannot provide that, it's impossible to provide. Either they deleted the data, or they for some reason or another, there's a server problem or change of server. I don't know. That gets into the really technical side of running a website or running a tech entity. But if it's impossible or requires some disproportionate effort, then those data requests do not have to go past, or would not have to be enforced past 12 months. And also, this is only on information collected after January 1st of next year. So basically a 12-month gap between now and then in terms of what type of data would be subject to that request. Very interestingly, and perhaps most importantly for businesses, in terms of how this will practically play out, is that it does create an express enforcement agency. So there will be a body of people, a governing body that will examine whether enforcement action should happen, whether a particular activity or lack thereof is in violation of the CPRA. So again, while the CPA or CCPA was somewhat passive in terms of how it, how it could be enacted, or how not enacted, but how a violation or potential violation could be assessed. This is going to be a very active agency to oversee that. And I think, broadly speaking, based on the way the CPRA is drafted, it is very clear now that businesses will need to craft very clear, very purposeful policies with regard to how information is being used and why, and then how long it's being used. So, and that's again more in line with GDPR and definitely pulling it away from what the CCPA had done in the past. And in terms of use, we're really looking at what is reasonably necessary, and in terms of retention, the CPRA is going to require that data be kept no longer than basically reasonably necessary to accomplish a specific purpose. And that purpose must be expressly stated, and data cannot be used outside of that purpose unless you're going to provide that purpose as well. So if there are multiple purposes, you need to provide both, or provide 3 or 4, however many there are. So again, this is much more like what GDPR requires, and I think if you're already following GDPR, if you're already concerned about GDPR, if you think GDPR is in your future, if you're not necessarily subject to it at this point, the CPRA coming online in the next couple of years will largely track with GDPR in many ways. So just a couple of summary questions. What should be done now? I think that the biggest thing, and this is where when we have clients call and ask, do these apply to me? Or should I be concerned about them? Or are we worried about them? Please help. I think the biggest thing is that maybe the overarching theme of all of this is that I think as a society and really globally, we are headed in this realm of where privacy matters, and people really care about. A lot of people really care about this. And so even if you don't meet the technical definitions, if you run a business and you don't meet the technical definitions of one or either of these, it still sets up really good practice. And when we have clients who don't meet the scope of either the CCPA or the GDPR or the soon-to-be CPRA when it comes online, it's still really good guidelines, and it still gives very clear instruction for what is really best practice for if you're running a website or running some type of data processing or collection operation. And so, I think even if it doesn't apply to you, I think try to stay close to it, try to stay within the spirit of both of these. If they definitely apply to you, or you feel like they will definitely apply to you moving forward, go ahead and start now. Start in the next 6 months figuring out where there's gaps in the new requirements and what can be done to address those gaps. I think we've kind of seen with GDPR in the last 4 or 5 years that it can be kind of the enforcement can be kind of clunky to figure out in terms of what's going to happen, who's going to do it, what is this going to look like, who's going to business-wise is going to get in a lot of trouble, and what is that going to be? Whereas I think we've kind of seen that now. So go ahead and start figuring this out now. How should we feel about these changes? It's certainly a complex answer. As a business owner myself, it's something to be concerned about in that it's just another compliance piece that you have to undertake. But again, I think viewing it as, and the company I own is nowhere near applicable to any of these. We're much smaller than that. But I think, again, viewing it as a best practice and viewing it as a lot of people do care about this, and not just people in the EU, not just people in California. And so I think the best way is to just view it as a best practice, even if you don't necessarily technically fall into the scope of these. View it as these are guidelines I need to follow because my customers expect it. And I think by and large customers do, and I think moving forward customers will. And then what will enforcement look like? And I think as we've seen with GDPR, it's going to be moving a forward-looking, ongoing process where we're looking at, how does this governing body, for example, how does this governing body enforce these? How does it prioritize enforcement? The regulations to fit this enactment have to be built out. A lot of those regulations for the CCPA that was enacted 2 years ago are just now coming online, are still rolling out. So it is going to be an ongoing process. But I think, again, the I think the really important takeaways are view these as best practices. And I think if we now read these as, if I'm meeting GDPR, I'm probably very close to meeting the CPRA or vice versa, with some obviously some procedural and some minor substantive differences in places. But I think the general spirit of both are largely together, largely track. And so again, I think it's just really important to view this as, this is where we're headed. This is the winds of change are blowing in this way. And regardless of how big your business is, very large or very small or somewhere in between, this is a great opportunity to get out in front of something and really show your customers that that this is something you care about. Do we have any questions?
Nothing yet, but if anyone has any questions, use the Q&A or the chat function, and we will read your questions and try to answer them. But in the meantime, Andrew, you have some questions, correct?
Absolutely. So I think one of the really interesting things about this that interested me on this topic, and it interests me when we discuss it with clients, is how to make sure that what you're building in terms of privacy policy or looking at what the company already does and making sure it complies with the CCPA and with the CPRA moving forward, is to really get into what's being collected, how it's being collected, and really thinking through who has access to this information. And I'm always amazed when we do these privacy policies, how many people, I mean entities, how many businesses, how many service providers have access to information. And it's usually, when we do these, it's usually 8 or 10 at the least. You have, the ISPs, you have the, hosting sites, you have, if it's an app or something like that, you have a development team, you have sometimes other tertiary services, for example, email marketing services and things like that. Obviously social media, if that's plugged into what you're doing. And so it is surprisingly broad sometimes about how many different entities really have access to specific types of information. And so I think, again, if you're drafting one of these privacy policies or looking forward to how do I comply, if I'm not already subject to one or both of these, how do I comply? I think really thinking through, taking the time to think through who has access to this information and what do they do with it. And if you're thinking through those questions, it should be, complying, not necessarily easy, but in terms of putting together what should be there, it's going to help a lot. And it helps us when we draft these policies. Robert, I see a question. I don't think I can read it.
Yeah. Besides California, are there any other states thinking about similar legislation?
That is a great question. And I did not look into that for this particular presentation. I probably should have done, but I did not. I do know Massachusetts has a policy that applies to data and information, but it is decidedly more narrow than California, and it's really about basically making sure that information is available to the consumer about what's being collected. It's not really whereas GDPR is a very clear set of policies, procedures, and what happens if you don't do those things. The CCPA is a very clear set of, we want this done, you need to tell the consumer X, Y, and Z. And then the CPRA is going to be much more like GDPR in that it has that clear enforcement mechanism. There's no other state that has anything close to that. And I'm sure, and I've in the past looked into, are there states considering it? I do know there are other states considering it. They're looking at this. But in terms of specific states and when that might happen, I can't say. One more thing, just kind of supplemental to that, is that I do think now is a really interesting time. Obviously Europe has a considerable leg up on protecting data and protecting privacy for its citizens. California is obviously headed in that direction, and how quickly other states get there is an open question. But I do think it's a really interesting time from a potential policy perspective to very clearly across the U.S. marry those standards with what Europe has already done and build upon what California is doing. And so I think if you care about data privacy, and as a business owner, we want to make sure our customers' data is protected. When they entrust us with that, we want to make sure that it's secure. I know here at the law firm, we want to make sure data is secure and information about our clients and about everything about our clients is protected. And I think everyone does care about that. And so I think it's really important that it's a great opportunity, a great time to look at what's being built upon the scaffolding, so to say, and build something that maybe is broadly recognized around, I guess, certainly Europe and the United States, and maybe toss in Canada as well. I did see last night, Canada, I think, is either considering or soon to enact something along these lines as well. So it is really gaining steam among among many parts of the world. And I think there was another question too I saw.
Yes, it's about getting a copy of the presentation. To answer the question though, yes, we're going to be uploading this entire presentation on YouTube. So if you check out our YouTube channel, which I'll type it in the chat as well, we'll have it on there by the end of the day.
Excellent. Well, I think if no one has any other questions, stay tuned. I think this is obviously a very open subject that we will revisit, and we'll monitor when regulations are drafted moving forward the next few months, and how this where this is headed and how this starts to play out. So stay tuned. I think we'll definitely revisit this. Robert, do you have anything else, or I think we're good for today?
I'm good. So the only other thing is we have another webinar this same time next week, and it's about why you should hire third-party engineering crews to help your company with tedious work. So if you click the link that I just sent in the chat, that will allow you to register for next week, same time, Tuesday, 10 o'clock. Eastern time, and that is it. So Andrew, if you're done, we can end it right here. Thank you everyone for joining.
One more quick, I should have added this earlier. This is a very, very broad, very high level survey of all of this. There are lots of nuances to many of the things we talked about. It was just, we could quite frankly, kind of like maybe talking about GDPR three or four years ago, we could talk for 5 or 6 hours on this topic and still not probably cover everything. So if you do have questions, or if you say, well, I'm questioning about this particular right or this new requirement, does it apply to me? We would be glad to answer those and look at and kind of anticipate what might be happening moving forward, or how maybe the data you collect or the way you use it is different or somehow treated differently based on those nuances. So please, by all means, if you do have questions, or if you feel that further explanation is needed on a particular topic or subject, feel free to reach out, and we absolutely will explore that together.
Thanks everyone. Have a good one.
Thank you. Have a good day.